In this video, I am going to be talking about everything you need to know about domestic violence in California in 2023. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I am going to be telling you 7 things that you really need to know about domestic violence in California in 2023. Okay, so the first one is that the victim or alleged victim of domestic violence charges cannot drop the case. You hear this on TV all the time, pressing charges. Does the victim want to press charges? It really doesn't matter in California. Once I realized that, whenever I watch those court TV shows, it drives me crazy. But it really doesn't matter. Once you call the police, once the police come out, once they file a police report, they make an arrest, it really makes no difference. As the victim, you are not in charge of the case. It's not your case. It belongs to the prosecution. So that is one big, very, very frequently asked question, and one thing that understandably people often do not really know about until they're actually in this situation. Number 2 is you need to have an attorney contact the prosecution before the first court date. Many times people want to just wait, see what happens, see how it goes at court. Oh, maybe it will be reduced, maybe it will be dropped. Okay, so here's how it works. When you get arrested, the police generate a police report and they send it to the prosecution. Prosecution then decides, do we want to file more serious charges, the same charges that you were arrested for, less serious charges, or drop it all together. Now, whatever is in the police report, if you were arrested, is not going to be good for you. So you need to have an attorney contact the DA, contact the prosecutor before court to explain the good things about you, explain your side of it. That is really, really important. If you just do nothing, yeah, it's possible that they'll drop it down to a misdemeanor if it was a felony. It's possible that they will throw it out, but why would you take the chance? Especially when people call me, they've never been arrested before. This is the first time. They have a good job. They have a clean record. If you care about that, if you want to make sure that your record stays clean, the best way to do that is to get the whole thing dropped before court. And if you think, but I'm a good person, I have a good job, I've been with my wife for 10 years, it was just a misunderstanding, we have a newborn, whatever your situation may be, the thing is that stuff is not going to be in the police report. That is stuff that should be taken into consideration. Those facts are important. But the prosecutor who's looking at this police report for 30 seconds, 1 minute, doesn't know about any of that. They'll see that and they'll see that you have no criminal history, but they will not know any of the good things about you. When you're like, but I'm a good person, they won't know that stuff. So you need an attorney to explain your side of it, to get that side of it over to the prosecution when they're making that decision. You don't want the prosecutor to just look at this based on the police report. And let's say that you do have a criminal record. Let's say you're like, well, fuck it, I've been to prison, it doesn't matter. Who cares about my record? I'm a felon. The thing is, if you do have a criminal record, yeah, maybe you don't care as much about whether there's another black mark against you on your record. But the thing is that you are the type of person then that they are going to try to send to prison or send to jail for this offense. So even for you, if you do have a criminal record, you do want an attorney to contact the prosecutor ahead of time and see if they can get this thing dropped down. Now, if you are one of those people and you have a record, you may think, well, that didn't happen with any of my other cases, but if those were more serious cases, those are probably going to be filed anyway. Domestic violence is one of those types of cases that oftentimes does not end up, well, not oftentimes, but I will say that the prosecutor really takes a good look at these cases and decides, do we want to file these or not? And the reason is, if you have been in this situation, you know the cops are called by either you, the other party, a neighbor, whatever. The cops come out and they arrest someone, and maybe they had a good reason to arrest that person, but maybe not. And the prosecutor knows the same thing. And they cannot, for every one of those arrests, they cannot open up a criminal case and spend all of these resources on prosecuting it. So those are the types of cases that the prosecution really thinks about. Should I prosecute this or not? And it's really important to get in front of them and tell them, no, you shouldn't prosecute this one ahead of time. Number 3 is at the first court date, the prosecution is always, I guess I'll put an asterisk because I haven't seen every single proceeding that goes on, but their policy and what I've seen them do every single time is they will always ask for a restraining order to be placed against the defendant so that he cannot contact the victim. So in some cases, that's not a problem. Maybe you were just dating the other person, you guys broke up, you don't care, you don't want to contact them, they don't want to contact you, who cares, so what? Where it does make a difference though, obviously, is if you are living together. I've had situations where my client is the one who's actually on the lease, who's paying for the apartment or the house or whatever it is, or the mortgage on a house. Maybe he owns the house or she owns the house. And what can actually happen is that you can get kicked out from your own place that the other person was just, basically a guest in or living in, sometimes for free, and they can keep living there for free while you are still on the hook unless you want your credit to be messed up, your landlord to evict you, your house to go into foreclosure. You're still stuck paying even though you cannot go back to your house. Another situation is a husband and wife or boyfriend, girlfriend, whatever, they want to stay together. Maybe you have kids together. You absolutely don't want this. It would be a financial hardship if one of you had to find a different place to live. So it's very important at the first hearing to be prepared to fight against that restraining order. That restraining order is one of the worst things that happens in these cases, especially for families. I've had families where there are like little kids involved, and one where I had a defendant who was a mother who was breastfeeding, and they're trying to place this restraining order where she wouldn't be able to see her husband or her kids. I mean, that's crazy. And so we had to fight against that. So it's really important to know that that could potentially happen. If you are on good terms with the victim, if you guys want to see each other, if you're living together, whatever, you have kids, have the victim come to court that first day, and your attorney can give the victim a chance to address the court. And that can be really important in the judge's decision as to whether to actually sign off on the restraining order or not. Number 4 is start classes. Now, if you just got arrested, you have court in like a week or two, there's no point in you doing this right now, really. You can probably wait and see if charges are going to be filed if you already have an attorney who's contacting the prosecution and all that. But if charges have been filed, you should start classes now. You should start domestic violence classes right now. It is different in each county. I made a video about doing that in Los Angeles County, but contact your attorney and figure out, okay, which domestic violence classes can I do? And the reason why I'm saying contact your attorney is that you want to make sure that they are court-approved classes, court-approved for criminal court. So sometimes if you look online, they'll say, oh, court-approved domestic violence classes. So you might think, aha, that's what Veronica was talking about in the video. That's what I need to do. Be careful with that because sometimes it's approved for like children's court or family court, but not necessarily criminal court. And then you won't get any credit for it later. I mean, it can still potentially look good for you. I mean, the point of this is to show the judge, show the DA that you're taking this situation seriously. And by the way, it's not an admission of guilt. It is something that makes them think, okay, I feel safe that this person is taking the case seriously, that no matter what happened that day, maybe it was just a bad argument, the police made the wrong call, whatever it was, they feel like, okay, you never want to be in this situation again. They're not going to see you back here. And that can go quite a long way. Number 5 is be persistent. And number 6, and I'm going to tell a story about these, which is why I'm kind of sticking them together. So number 6 is if you can't get a non-jail or prison offer from the prosecutor, ask the judge. Okay, so I'm going to tell a story about a case that I had recently. And so I had a potential client who called me a while ago, like over a year ago. We talked for a while. Ultimately, he told me that another attorney gave him a cheaper rate, and so he was going to go with that attorney. So I said, okay, fine, that's fine. So he does that, and then I hear from him maybe 3 months after that saying, all right, so I hired that other attorney, but he's telling me that my offer includes 60 days in jail. And, he said, okay, this is my first time domestic violence case, 60 days in jail. And I thought, well, that's like, did you have really bad injuries? Like why would it be 60 days? You have no criminal history. That doesn't make any sense. And he said, well, yeah, I know. I don't know. Like, I have no idea why it's so bad. And I asked, well, what does your attorney say? And he said, well, it's because of my history. And I said, well, what history? What is he talking about? Well, I don't know. I have no idea. And, we went back and forth. I told him, like, go talk to your attorney again, try to get this information. Never did they come to any kind of understanding as far as I could tell. So eventually he hires me. me. And by the way, that means that he paid the first attorney a reduced rate, which was, I don't know, $1,500 less than I was charging him. Plus had to pay me, didn't get a refund from the first one. So, you go cheap, you pay twice, buy cheap, pay twice. I don't know. It's kind of like shoes, I think. But anyway, so he hires me, I take over the case, and I find out actually he did have another domestic violence case, and he did already get probation for it. He did already get classes for it a few years back. I asked him about it. He doesn't really remember it that clearly. He remembers something like that, but he didn't think that it counted as a criminal case. I don't know, but I'm looking at it, I'm like, well, this is the exact same charge. This is really bad. Of course, this is why they are offering 60 days in jail. So I send him to classes. I send him to therapy. Like, just get as much of that done as you can, please. I talked to the prosecutor. Prosecutor's like, no, like, this is the second time that he's done this. He obviously didn't learn anything from probation. He didn't learn anything from 52 classes that he had to do last time. So no, we're not giving him a better offer. I submit the mitigation packet. And I'm going through to see if there's a lot that can be done to fight the case. It would have been a risky trial for him. So we get a different prosecutor. I try with that prosecutor. They tell me basically the same thing. Go after yourself, Veronica. Fine. I talk to the DA's supervisor, so that's usually the next step. I set up a meeting with him, the grand supervisor of the whole courthouse. Sit down with him, talk to him, and he's like, wait, why do we charge this as a misdemeanor? This should have been a felony. Wow, look, these injuries are bad. This is the second time this guy's done this thing. No. Heck no. So, and I'm really trying to help this client, and I actually think that I think that there was at least somewhat of a misunderstanding, and I think it might have been kind of a self-defense situation. I never really know, or at least most of the time I don't know, but I felt for this client, and I also want to do my job, and I don't want someone to hire me and then I'm not able to get him a better offer. So I just had a second meeting. I had him do, he's doing more and more of the classes, more and more of the therapy. I have a second meeting with the DA supervisor. Again, go after yourself, Veronica. We don't care. I'm trying to get him like house arrest, community labor, something. Meanwhile, the client is obviously stressed. I'm telling him like, hey, like, I'm taking care of this, but I can't offer him a guarantee. Like, I don't know for sure, right? Like, I'm trying, but I keep getting just totally shut down. And, it's true. When you had a prior domestic violence only a few years before, you got probation, you got classes, and now you're back with the same offense. Yeah, most prosecutors are going to say immediately to jail, right? So the case is marked no further continuances by the judge, because there have been many hearings between the first attorney and me. I'm just coming back every time. I'm being persistent. I'm telling the client, just keep going to the classes, keep doing the therapy, just keep doing it, keep giving me proof of this. I had the client write a letter about what he learned in therapy and in domestic violence classes. I had him get even more letters of like recommendation and support. And at the no further continuances, like final check-in court date, I talked to the judge. So we have number 5, be persistent. I was persistent. Number 6, talk to the judge. Okay, so I asked the judge for an indicated sentence. So an indicated sentence is where the judge tells you if you were to just plead no contest as the defendant, you were to just, instead of saying that your plea is not guilty, you switch it to no contest, or in some counties, like Orange County won't do that. It's guilty there. What would they sentence you to? So I talked to the judge. I made my pitch, and the judge, so I can't give too many details about the case, but the judge seemed like he had been in a branch of the military or something before, like he would support that. And my client has a profession where he can potentially do things that would be helpful for those people. So, the client had told me, like, anything, give me a house arrest, give me community labor, community service, I don't care, like, whatever it is, but I cannot go to jail. So I convinced the judge, I talked to the judge, I convinced the judge to get rid of the jail time and instead to give him a whole bunch of community service serving former veteran. And that actually worked. So finally, after many months, after paying 2 different attorneys with number 1, persistence, number 2, going to classes, that was important too, and he wasn't doing that until I told him to. And number 3, talking to the judge and making this pitch to the judge, we were able to finally get him what he had wanted all along, which was a non-jail misdemeanor offer that can be expunged. Now, about indicated sentences, I will say that in general, you want to be very careful with that because you have to plead guilty or no contest to everything you're charged with in order to get that. So for my more serious felony cases, that is not going to be an option sometimes because of mandatory minimums. But for a case like this, and for domestic violence cases generally, it is actually an option. Number 7, the final thing that you should really know about domestic violence in 2023 is that if the victim doesn't show up for trial, it does not mean that the case is necessarily dismissed. What that is going to depend upon, it's on a case-by-case basis, is what other evidence they have that can possibly be admitted. So what they could have is maybe they have body-worn video from the cops interviewing the alleged victim. Is that admissible? Maybe, maybe not. Depends on the circumstances. There are a whole bunch of laws on hearsay, admission of evidence that could maybe bring those in or maybe not. Let's say that she had really bad injuries or really visible injuries that there were pictures of. That can be used against you. If there was a neighbor or somebody else who is a witness, that can be used. Maybe when the cops showed up, they actually saw or heard something or heard an argument, that can be used. So it doesn't necessarily mean the case dismissed. So typically by the time you get to trial, you've rejected a bunch of offers. What you don't want to do is get to that point and nobody's explained to you, hey, if the victim doesn't show up, they might still pursue you at trial. You could still potentially lose. You want to make sure that you know that and you're going forward with all of the information. So one thing to ask your attorney in a domestic violence case is, hey, if we were to go to trial and the victim didn't show up, what evidence do you think they would still be able to use against me? That is pretty important. Anyway, those are all of the most important things, the 7 most important things that you should know about domestic violence in California in 2023. If you do have a case in California that you need help with, feel free to give me a call. You can find my number down below. You can also book a consultation with me there.